This is Ellen Morris, and I'm Howie Krooks from Elder Law Associates. Today we want to talk to you about the importance of doing advance directives. A lot of clients ask us, what is an advance directive? And the answer is that it includes a variety of different documents that enable you to plan in advance to appoint other people to make decisions on your behalf. For example, for financial transactions, you can sign a durable power of attorney. That will allow your agent to take care of your financial transactions, like going to the bank, dealing with insurance companies, dealing with the IRS. It also would include dealing with government benefit agencies, Medicaid, Medicare, the Social Security Administration, the Veterans Administration. These are really important documents because you never know when an incapacitating event could occur, and this could happen at any age. We have clients who have children that are 18 and over and in their 20s and 30s, and an incapacitating event can happen to them, or as people age, things like dementia or Alzheimer's may set in, requiring somebody else to take action on their behalf. So on the financial side, we recommend a durable power of attorney so that when you become incapacitated, you have an agent to act on your behalf. And I'm going to let Ellen talk to you about how we handle decision making on the healthcare side.
So on the healthcare side, we want our clients to name and appoint whomever they feel would be the best person to make decisions for their healthcare if they are unable to do so. And that's really crucial because we don't want it to just be maybe next in line under our statute. Maybe it's your youngest child who is a doctor or has medical training that you want to make your decisions for you. Maybe it's your spouse. Maybe this is a second or third marriage and you want your children, not your spouse, to make your healthcare decisions for you. But the importance of signing a healthcare directive is, unfortunately, sometimes even temporarily if we're just going into surgery and we're on anesthesia. But unfortunately, there are times when we may not be able to express our own decision to a doctor regarding our health care and what we want to have happen with our health care. And so a very important document is a designation of healthcare surrogate, naming who you want in the order that you choose to be your healthcare surrogate and make decisions for you if you can't make it for yourself.
And Ellen, I think one other form that we can talk about is the Health Insurance Portability and Accountability Act, which allows you to name other people to access your private medical records. And that can be a really significant document because without it, your family members do not have access to your confidential medical records, and healthcare providers can be held both civilly and criminally responsible for releasing those records in violation of this law. So if you want your family members to be able to access your confidential medical records, you must have what's known as a HIPAA form, a medical release form, thus allowing them to access those records. And that could be significant either to monitor somebody's ongoing care needs and accessing the medical records for that purpose, or if in the situation where if there's a wrongful death action or a negligence action, you may need your family members or loved ones to be able to gain access to those records, but they can't do so without that HIPAA document.
And what's really important there is you may name your youngest child as your healthcare surrogate, and so that person may be the decision maker, but you may list all of your children to receive your healthcare information. They won't be the decision makers, but they can stay in the loop through this HIPAA doc. And the last document that we should talk about is the living will as an advance directive. And you probably are familiar with the concept of a living will as to whether you want heroic measures to be taken if you are in a life-threatening, death is imminent situation, or you are in what's called as a coma or a persistent vegetative state. And without a living will, doctors may be compelled to keep you alive using heroic measures. So if you believe in a living will, our living wills provide a lot of different choices. Do you want food and water or don't you? Do you want experimental treatments? They may or may not have been approved yet. Do you want a certain living will not to be put in effect, meaning do you want to be kept alive until maybe your children who live out of state get a chance to come and say goodbye to you. So the living will is a very important document that you should consider.
So we here at Elder Law Associates are here to help you to decide on which advance directives you should put in place and how to structure those documents. So give us a call, come on in, and we'll get your advance directives in place.